Today on Off the Clock, we are going to be talking about the EEOC's new guidance on harassment in the workplace. Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
There is this very long, new guidance, nothing earth-shattering. I didn't think. What did you think? Was there any? And we'll get to the details in the discussion in a moment. But
I wasn't overly surprised, about what they had to say.
Yeah.
There were a few things I kind of picked out, and I thought to myself that it would be important to me that our listeners and HR folks in general also know this is where the agency stands, right? With these particular issues. So we have some things to talk about for sure. I think it'd be helpful to quickly level set about what unlawful harassment is, because it's easy to read or hear about bits and pieces of what the commission says about it and run with it without putting it back into context of the legal requirements for harassment. Right. In other words, what type of behavior is actually unlawful in the workplace?
This comes up, I know, for you and for me often. Employees, when they make reports to HR, often use the phrase harassment or hostile work environment. Right. And it has nothing to do with the legal definitions of harassment or hostile work environment, right?
Right.
But those words, they know it will get HR's attention. And then we sometimes have to bring people back down.
Reground them.
Yes, this is an employee relations issue.
Right.
But not a legal issue. So for both of those reasons, I think it's great just to level set.
Let's just for a second, reground ourselves to what the definition of unlawful harassment is. So basically, first of all, it has to be conduct that's based on a protected class, right?
Yeah.
And we generally know what those are. Age, gender, disability, religion, etc., right? So it has to be based on some sort of class that's protected by law.
Right.
Okay. But not only that, it has to be something that's very significant, right? And there can be two ways it reaches that threshold. The first way is if somebody with supervisory authority themselves is engaging in the harassment, in the behavior based on the protected class. It can become what's called quid pro quo harassment under the law, which is, by the way, why it's so important to be training our leaders about harassment in the workplace and why their role is so important in making sure that doesn't occur. And then the second type is if it's behavior in the workplace that's coming from coworkers. Okay, then that behavior has to rise to the level of being severe and pervasive, such that it creates what you and I call a hostile work environment, right?
So one offhand comment, either intentional or not. Sometimes people put their foots in their mouths sometimes, let's be honest. But sometimes it is intentional. But one over the course of a career does not make a hostile
Certainly
work environment.
Not. That's exactly right. And the reason behind that is probably obvious for our listeners, right? And that's if businesses couldn't exist if we were going to hold them liable, right, for every single offhand comment, joke, etc., that somebody might make in a workplace, right? What we can do as employers is have policies in place and conduct training and do our very, very, very best to try to make sure our employees treat each other with respect and dignity, et cetera, et cetera, et cetera. But at the end of the day, we can't practically prohibit anybody from ever saying or doing anything that's offensive, right?
The language that the courts have, one court, I guess, using and others keep repeating is employers are not required to sanitize the workplace. They can't, right? They will not be held liable,
it's
legally
human
liable.
Beings,
if they
after
haven't
all, right? Yes,
sanitized.
Exactly.
The yes and I want to put on that point because you said that very well. Couldn't have said it better, and I won't. So my yes and is that does not mean we don't do anything.
Of course.
When there's one comment. Sometimes people, when I'm doing
good
trainings and presentations, people will hear me say something like that, although not said as well. And they'll say, well, does that mean when there is one hurtful, let's just call it hurtful, comment, that we do nothing or should not do anything because it did not rise to a hostile work environment? The answer to that, I can already tell because you're nodding your head, you're going to agree with me. I always say, no, you address it to make sure it's only
it doesn't get to the point of being unlawful.
Yes.
We don't recommend that employers allow behavior to ride up right against that line of being unlawful and then take action.
Right, exactly.
And that leads nicely into the third requirement for conduct to be unlawful, harassment, and that is the employer has to be liable for it. Right? And there is a defense that employers can make with regard to that hostile work environment type of harassment, and that is if they've got a framework in place, including a policy that provides employees the opportunity to raise concerns about what's happening in the workplace, and then the employer takes prompt and appropriate remedial action when it occurs, then there's a defense to be made there.
Yes. So even when bad things happen, if we respond appropriately as the organization, we will still be okay.
That's exactly
at the end of the day.
Exactly right. Yep. Okay. So with that, quick harassment 101.
I can't believe we got through that fast. By the way, can you?
I know.
Okay.
Let's talk first then about what the commission had to say specifically with regard to harassment based on sexual orientation and gender identity.
Okay. Yep.
So the first thing they said, really, I'd use the word confirmed because this is not a surprise at all. Right. They acknowledge,
not to us at least.
At least not to us.
It might still, I mean, in fairness.
So they acknowledged that both sexual orientation and gender identity are classes protected by law under federal law, under Title VII.
Yep.
The U.S. Supreme Court has said
that. Yes.
Which means then that they can check that first box, right? That harassment in the workplace based on those classes could be unlawful, right? So to be clear, though, that means that just checks that first box that for behavior to be unlawful, then an employee would have to still demonstrate the second two, including that potentially it's creating a hostile work environment. Does that make sense?
It absolutely does.
Then, more interestingly, they provided lots of examples over the course of many, many pages of the types of workplace behavior based on those classes that they think could rise to the level of being unlawful. Okay? And good news, I've just distilled them right down here, so we're not going to... for you and the listeners.
You sound a little resentful that they took up so much of your time, by the way. Well, I have to be honest. I know you've been busy.
As you know, we've been reading a lot of rules and guidance and regulations lately, right?
Yeah.
Hundreds and hundreds and hundreds of pages.
It's almost like the current administration is concerned they might not have much more time. So they're getting it all out. Yes, and you do seem resentful of all those hundreds of pages that you had to read.
I will never get those hours back. Okay, so here are the types of behaviors that they specifically identified could constitute harassment if severe and pervasive, okay?
Okay.
The first one is intrusive or invasive questions.
Okay, I think that's very interesting and will take some people by surprise.
I agree.
Do you think so?
I agree. And when presented, it was couched specifically for transgender employees who were transitioning from one gender to a different gender, right? Or even, if not physically transitioning, dressing, right? From one gender to another. So what the commission said is that unwelcome questions. Yeah, even questions.
That are not in themselves derogatory, right? That are not laced with derogatory terms or judgment.
Being inquisitive, right?
Unwelcome curiosity.
Among coworkers could rise to the level of being unlawful. Now, again, remember, like we started with the definition for a reason because we're going to keep moving back to that. Those questions would have to be severe and pervasive and offensive, really, both objectively and subjectively offensive. And also, if from a coworker, that employee who's the object of the questions would be expected to bring it to the attention of the employer and give them an opportunity to address it, okay? So, but I think that that is a helpful data point for HR folks to understand that questions like that, intrusive questions, could be harassing to an employee.
Do you think the concept, and we're going to coin a new phrase, Sarah. It's going to be our catchphrase. It's not going to be our catchphrase. But obtrusive curiosity could apply outside of the specific context, let's say religion, for
I was going to
instance.
say religion.
So
really
someone that
comes to
celebrates
mind.
different holidays, has different customs, ethnicity, national origin. Are they saying employees, coworkers should hesitate to ask each other about their traditions and their, all the things that could you think questions like that, obtrusive curiosity, could rise to the level of a hostile work environment?
Or genuine curiosity. I want to learn more about your faith. I'm curious about your faith, maybe because I like you and I care about you as a person and I'm interested in hearing about your religion.
But the EEOC does not have an exception if your curiosity is genuine.
Right. No, that's
It's just if it's obtrusive in the eyes of the person who is receiving the questions, right?
Yeah.
Does intent matter?
I don't know.
I
think it's a great
don't
question.
know either, but
and
it
it's a
is
good point.
food for thought here.
Religion, disability too, could be a situation in which we see that. Like everything else, it's the spirit in which that communication is being made from one coworker to another. And again, if questions on their face are not offensive, right? The employer's not going to be liable for that. It's not going to be unlawful unless it creates a hostile work environment and the employee did not bring it to the attention of the employer, assuming the employer has that framework in place to address.
So the message to our listeners, the takeaway is, if an employee comes to HR leader and says, so-and-so has been asking me repeatedly questions about X, Y, or Z, and it makes me uncomfortable. You don't say, the reaction should not be, well, they're just questions.
Right, that's correct.
Or so-and-so didn't mean anything by it, or so-and-so's just, it's
could
not a
rise to
brush-off moment.
Yep, that's a great point.
I think that's the takeaway here. I think we say, we have a conversation with the person who is asking the questions and let them know, even though that wasn't their intent. Maybe it was sometimes. I've had a case, by the way, where questions, I think, were intended to make someone uncomfortable.
Right.
But if it seems as if that was not the intent, we can say, regardless of your intent, so-and-so doesn't feel comfortable talking about it and answering questions, so can we just stay away from that issue?
Sure.
Right?
Yep.
Okay, so maybe that is the takeaway. It's not that we can never discuss what makes us unique, right? And because there's this movement, engagement type of concept about bringing our whole self to work, right? And all the things that come with it. So there's a little potential conflict there. Okay, enough about that.
Other things that the commission identified as potentially harassing on the basis of sexual orientation and gender identity. This probably isn't going to come as a surprise to you, but repeated / intentional use of pronouns or names inconsistent with that employee's own gender identity. So an employee has requested that certain pronouns be used to refer to them or a certain name, and a supervisor or coworkers are simply ignoring that request and intentionally referring to them by different names or pronouns.
Could it be
That can
unintentional
harassing.
but repeated? Could that also be a problem?
It's interesting. They used the word intentional.
Okay.
At some, I hope we never litigate that question in a workplace,
Yes,
right? Whether
right.
somebody's repeated use of the repeated misgendering of an employee is intentional or not, right? I do think to that end, employees generally deserve a little bit of grace as they're getting used to using a pronoun that they wouldn't typically use for somebody, or maybe haven't been, right? Maybe they've worked with this person for a period of time and they're changing their brain.
Yes. To
but
rewire.
I do think after a period of time, when it's repeated and repeated and repeated, we probably need to maybe draw a conclusion that it might not be unintentional. Other things, requiring employees to dress according to their birth sex rather than the gender with which they identify, right? So the example given was an employer that requires female employees to wear skirts and male employees to wear pants, and a transgender employee wishes to wear pants, and the employer says, no, we are going to require you to wear a skirt instead because we believe that you should identify with this gender. So,
does that apply to non-binary persons as well?
I would think so,
Okay,
yes.
so a non-binary person should be allowed to choose which clothes to wear to work. Okay, got it.
I will say, you and I have been doing this for a long time, me longer than you. I do remember. I do remember earlier in my career reading a lot of dress policies that had different categories for male and female.
Yeah.
I see that much less frequently now.
I agree.
I think in general, workplaces are not aligned to wearing certain things based on gender.
Yeah, and that is...
that's probably good.
We always try to get to the practical.
Yeah.
That's a good practical.
Yes.
That's just good practical advice, right? If we don't have, clothes, grooming standards, et cetera, assigned to different genders, then we don't have to worry about this issue.
It's going to make it easier.
Yeah.
Okay. Next one. Disapproval of somebody's protected class. So coworkers expressing disapproval of an employee's sexual orientation or gender identity, or perhaps telling them that they should adhere to a different set of beliefs than they are, right? And maybe even telling them what the end result is going to be at the end of time. You're going to go to hell if you can, for example. That the commission deems can be harassing behavior as well.
That should not be surprising.
It should not be surprising, but it opens some questions that we are going to get to in just a minute.
Okay,
right?
But I just let me say that.
Yeah.
A coworker coming up to me and saying, "You're going to hell."
Right.
I hope no one thought that was okay.
Right. Yes.
Okay. All right.
Yeah. And then the last one is refusal to allow employees to use bathrooms or locker rooms.
Yeah. That's where the
align with their gender, right?
That's where the rubber has hit the road.
Right.
For clients I have talked to that have employees, right, that are either non-binary or transitioning.
Yeah.
That's where the rubber hits the road.
A lot of times, yes.
Yeah. Because that's where it has a closer impact, a more direct impact on colleagues who might share the locker room or the bathroom, right?
Yes.
Yeah, so other coworkers speak up sometimes.
That's exactly right. And so we knew that OSHA had said that employers have to allow employees to use the bathroom in particular. That aligns with their gender because it's a workplace safety issue not to do that. And so now we have layered on top of that the idea that it can constitute workplace harassment to not allow somebody to use the bathroom or locker room of their choice. Okay.
That's all for this episode. Rebecca and Sarah will continue the discussion of the EEOC guidance on harassment in the next episode of Off the Clock.